everyone. Hope you're doing well today. Thank you so much for joining us. I'm Elise Rosemarin. I'm a Senior Vice President here at AKAM. And today we will be talking about insurance and legal concerns, what to consider when taking on new building and resident projects. I am joined with wonderful AKAM specialists in the area, as well as a wonderful professional colleague, Peter Massa, who's a partner with Fox Rothschild. Christopher Alker, who is our in-house resident architect. He's also Senior Vice President of Building Operations here at AKAM, and Brian Boak, Director of Risk Management here at AKAM. So without ruining this party and getting it started, we'll move on. Just also so you know, we would love to have questions be answered throughout. We're also going to have a period at the end for questions and answers. We're going to record this and we will be able to circulate it to boards should they not be able to make it. So we understand you are working, you're volunteers, and we're here to do this. So we're happy to record this for you. So as far as today, we're going to do brief introductions, which you just did. Contractual risk transfer, we're going to discuss what that means. Labor Law 240, what the scaffold law is and the exposure to it. Resident renovation risks, potential exclusions in coverage, and then a Q&A session at the end. But please feel free to put your questions in the Q&A box, and I will look to it and try to put them through the questions and have them answered as we speak. All right, thank you. So let's talk about contractual risk transfer. Peter?
Sure. Hey, everyone. Nice to be here. Thank you to AKAM for having me. As Elise said, I'm a partner in the co-op condo group at Fox Rothschild. We represent between 400 and 500 co-ops and condos all throughout the city. And the reason we're here today, construction issues and insurance and risk transfer, has become an exponentially bigger part of our practice the last couple of years. For many years doing this, I didn't have to worry about insurance that much. I didn't have to deal with this stuff that much. It wasn't that big a deal. The last few years, I've spent more and more time on this. Nothing against insurance brokers, but I've had more and more calls with insurance brokers, dealing with insurance policies and all of these things. And that's because building insurance premiums have gotten exponentially higher because of Labor Law 240 claims primarily, which we'll get into as we do this. And the prime thing that everyone is looking for is risk transfer. And the basics of what that means is, instead of my insurance covering it, if there's a problem, I want your insurance to cover it. So we need to have a contract or a document that says if there is an insurance claim, your insurance has to cover it, and you being the contractor in most cases. So that's the big picture of what everyone's looking for. Brian, Chris, do you want to jump in?
So we look for a lot of things in reference to this, and our brokers do these reviews and analysis for us. And it's part of the contractual risk transfer is to make sure that you have a contract that requires the contractor to name the building board and property manager as an additional insured. But we also have to make sure that the insurance policies will actually stand behind that contract. And there's exclusions that we'll talk about later on that we'll dive deeper into. Go ahead, Peter.
Yep, and the exclusions and searching for those exclusions in many cases is a big issue, and why some of you listening to this may see projects delayed and don't really understand why. It was for a large number of years that we just made sure there was a certificate of insurance and some kind of contract requiring the insurance to be named. It was requiring the owner and managing agent to be named as additional insured. Right now, because so many contractors have junk insurance with so many exclusions, all of these policies have to be reviewed to make sure you're actually getting what you think you're getting. And that can delay these projects significantly. And it's crucial, and I know AKAM does this and we do this, is to try to do the insurance review as early as possible.
Correct, because you don't want to get all the way down the road, have the quote, finalize everything, and then realize that, oh, the person doing the facade work can't work over 2 stories, or there is a labor law exclusion, or there's what's called a subcontractor warranty or exclusion, which means the subcontractor has to have as good insurance as you, or they can't work on residential buildings, or there's a lot of different ways these are worded, so it's not always obvious what the exclusion is, and that's why we have our buildings insurance brokers who do this every day analyze the insurance wording in the contract to make sure it's properly worded, because we've actually seen contracts that have what's called reverse indemnification, and that is where the contract states that the building has to defend the contractor, which is horrible and actually causes your insurance to be non-renewed if you have items like that, because it's basically telling your insurance company you have to defend the contractor if something blows up.
Can I ask, what are some examples of projects that our buildings might be looking to do that pose this type of risk?
I think,
Every
yeah.
single solitary project
Yeah.
that a building does needs to have a contract, and we actually have a sample contract, so the lawyer doesn't have to spend, or the building doesn't have to spend money on a lawyer. We have a sample contract that can be used. For example, to show you how bad this is, we have a labor law claim for a $2,000 pump replacement project. Anything.
Yeah, so I think it's a good point to note that, and one thing we didn't mention here is, and Peter and Brian both said it in terms of reviewing the insurance, it's not just the COI that comes through, it's the actual policy, right? And so if you, and there's another point to make there, is that in those really small projects, like a $2,000 pump, you may not have a full project management team on that project because it's not a major capital improvement project, but you still need to go through the same rigor of reviewing of insurance, whereas when you're doing a much larger project, ideally you have a project manager and you are going through the full contract, the full insurance, asking the questions, crossing T's and dotting I's. But don't forget, the same pain can happen to you on these really small projects, which is where Brian and Peter are going.
Yeah, I couldn't agree more. I see it on a lot of small projects, and the problem is basically anything off the ground. Any work that's being done right off the ground qualifies under New York State Labor Law 240. Anything on a step ladder, anything like that. So it's not just hanging off the side of the building, it's inside the building as well. And Elise, I think you can flip the
Yeah.
slide.
Yeah, I was going to say, should we chat about that next? Yeah.
Yeah.
Because it's Labor Law 240 is about height, but there's 2 parts of that. It's if you fall from height, but that could be simple as tripping on a set of steps. That's
Right.
falling from height. And if something falls on you from above, and
Yeah.
it doesn't matter whether it was a tool, it could be the ceiling falls in during a fire restoration situation.
Yeah, if we can just maybe, Peter, if you can just expand upon what is Labor Law 240, the scaffolding.
Yeah, so this is a crazy New York State law, and I want everyone to keep in mind, New York State is literally the only state that in the country that has this, and why insurance is so much worse here than anywhere else besides maybe Florida. And it imposes, as the slide says, absolute liability on property owners for gravity-related injuries. As the slide says again, owners and boards can be held liable even if they're not at fault, which is why the risk transfer is so crucial and so important here.
Wow.
And
So that's anything. That's obviously scaffolding, local law 11 projects, but that's really anything.
yes, and plaintiffs' lawyers have really latched onto this the last few years, and it's become a huge industry. You probably see the ads on the buses from the guys that customarily do this. They're all over the place. We're getting these lawsuits all the time, and insurance companies for the buildings just don't want to deal with it. They'd rather not insure these buildings than have the risk of these claims. So the only way to make it work is to transfer the risk to the contractors. once buildings started doing this, contractors insurance started getting more expensive. And that's where all these exclusions started coming from, which put guys like Brian and me and Chris in the position of having to now go through these insurance policies to see if these exclusions are there and bring in the insurance professionals to do that. AKAM, our firm, no one really reviews these policies on our own. The insurance professionals do that as part of the standard process.
So yeah, how do you mitigate the risk you go through at AKAM as an example? What are the channels?
So the way AKAM is set up is our property managers will send, we have a specific form that they can use to fill out, but basically we need to know scope of work. We need to see the certificate of insurance. We need to see the general liability policy, the excess liability policy or umbrella liability policy. And we need to see the proposed contract, not a signed contract, the proposed contract. Once we gather all that information, we can send that over to the building's insurance broker. The insurance broker will look at, in reference to the contract, they will only look at the insurance indemnification section. They will not look at the rest of the contract itself because that doesn't apply to what we are reviewing. They will look at the contract to make sure that indemnification is there, primary non-contributory, a lot of other different pieces of the puzzle are correctly worded. We want the contractor to indemnify us, not the other way around. And we want to make sure that there are insurance requirements in there and that the insurance requirements match the insurance that the contractor has. So if it says the contractor's got to have 5 million, does the contractor have 5 million? Okay. And if he has 10, we don't want to limit ourselves to 5 because the contract could actually limit our coverage by saying less than what the contractor actually has. So we want the two to match. In reference to the insurance policies themselves, our brokers look over and determine if there are any exclusions, and that's why the scope of work and the insurance are important because one, we want to make sure that the insurance covers the scope of work. We've had contractors try and come in to do facade work when they're only insured for painting, or try and do facade work where they can't work over 2 stories, or bring in a subcontractor when they have a subcontractor warranty that requires the subcontractor have just as good insurance as the contractor. There are all different types of exclusions. They're all worded differently. There's not just like one exclusion.
My favorite one is exclusions for work in a condominium building.
Yes, yeah, that's a good one. That's a good one.
Yeah,
Or a residential building.
Yeah, but that's sort of the point. It gets that crazy.
I was gonna say,
Yeah.
before we move to the resident renovation risk, because these are now, the building risks, is there an example of, kind of what you've seen that is out of the ordinary, or maybe even in that can help our boards, put their heads around, why the umbrella policies are so high these days? I mean, that everyone talks about, and how difficult the umbrella policies are to get. And then does that cover what you're talking about?
Okay, so that's an insurance question, so I'll take that one. 4 years ago now, the umbrella market collapsed specifically because of labor law claims. Labor law claims are the type of claim that breach the $1 million in general liability, which is your first layer of coverage, and go into the umbrella. It used to be buildings could buy $200 million worth of umbrella liability for $8,000 a year. Now, well, 4 years ago, 2 of the major umbrella policies or programs that insured the what's called partially sprinklered buildings, which are the buildings that do not have sprinklers in the individual units, they closed down within 2 weeks of each other because too many labor law claims were going into the umbrella liability limits, because these claims could be $1 million, $2 million, $3 million, because if you have somebody fall from height, they get badly injured, there's going to be a lawsuit. Because of New York labor law, they can sue the owner of the property, which is the building. Okay. It actually is worse for co-op buildings because the co-op, not the tenant actually owns the individual units. So in reference to co-ops, if there is a claim in a unit owner's unit because of a contractor, they can actually sue the building because the building is the owner of that unit versus the tenant, because the tenant in a co-op owns an undivided share of the building. They don't own that individual unit.
And I've had a couple situations where this has happened. Yeah.
Yeah, I mean, we have a specific situation where a contractor's employee decided to stand on a 5-gallon bucket to put the last sheetrock screw in, fell, and there's a labor law claim against the building. So to help protect that, a good alteration agreement can help. It may not be perfect because a lot of these small contractors do have not great insurance and they may not have labor law coverage, but at least having the contract is a step in the right direction.
So
Peter?
that speaks to the resident renovation risk. So alteration agreements, which I know, Chris, you have reviewed, from an AKAM perspective. How can it expose the board to liability, and then how do you prevent that?
I mean, when you have a design applicant, they are generally responsible if if a job that needs to be permitted, meaning it's beyond ordinary repairs, and that's very outlined very clearly in the code that it needs to be filed and permitted, then it's on that design applicant, the architect or engineer, to follow the building code, handle, coordinate any necessary inspections and the like. However, in order to do that work, the owner of that unit needs to have their own insurance. They need to have the contractor that is doing the work on that unit for that filed work to have their insurance. That insurance, as Brian noted earlier, needs to be, name the board and and the appropriate parties as additional insured, and make sure that that policy that is reviewed if they're working in the building. So this is one of those instances where we like to, number one, is ensure that any kind of claims that will potentially go to insurance. I mean, so for example, if you do work in a building and they put a screw through a pipe that creates a gas leak or a flood or what have you, right? Often the communication is between the resident who's a contractor created the problem, and then, whatever damage on surrounding units occurs. However, if they don't have the proper insurance in place, then it could potentially spill over into the balance of the building. So number one, we want to make sure that those alteration agreements are bulletproof on the insurance requirements. And then number two, they have belts and suspenders on, policies in the building as to when they can work, what inspections are happening, that they are following the bylaws of the building, they're following the DOB laws, they have the proper protection plans in place and everything. Anything to sort of mitigate the building liability. If the building doesn't provide them with the information that they should be following, regardless of whether or not they should technically know that, I think it could adversely impact the building. So we want to make sure that those alteration agreements are, like coloring books. They're very dumb and very spelled out so that everybody knows their responsibility.
I want to jump in on one more thing here because I think it's really important and a lot of people don't realize it regarding alteration agreements. It's great if the alteration agreement says the contractor has to name the co-op or condo as additional insured, but the contractor actually has to sign a document, either
Agreed.
the alteration agreement or a separate insurance and indemnification agreement, agreeing to do that. Almost every contractor policy at this point has something that says anything additional insured is only as required by written contract. So without a contract between the parties saying that, even if you get a certificate of insurance saying they're additional insured, it doesn't mean anything. So that's a small step that buildings can take that can help a lot.
And we have a sample contract for unit owner specific. No, we have one for building work and we have one for unit owner work. So if it's not in your alteration agreement where the contractor has to sign the page that says the contractor has to name the building board and property manager as additional insured, we have a specific document just for that. Because as Peter said, the certificate of insurance really doesn't mean anything in reference to providing coverage. All it does is gives a snapshot of the limits of coverage that are in effect on a particular day. If the certificate of insurance says that the building board and property manager are additional insured, it means nothing. It means nothing at all. It provides no coverage.
Brian and Peter, can you comment on, so normally in alteration agreements and even more importantly on larger capital improvement projects and buildings, we think that AIA contract documents are pretty typical and standard. Do you have any comments on those?
Peter, you can start and I'll finish.
Yeah, I think it's much better than a standard contractor one-page proposal. And if that's all you can get, that's great. We also, and most lawyers do, have a form of rider that we attach to these that go more in depth into the insurance and then indemnification and other things. And generally, when I'm doing one of these, I'll send it to the building's insurance people and say, this is what I'm putting in there. Does it work for you? Does it work for what the building needs? And we customize them to whatever the building needs. So again, an AAA is better than just signing the contractor's proposal, but having attorney and insurance company review and a rider goes even further and is important in many cases.
Could I also just tack on there, to anybody who is not aware, the AIA is the American Institute of Architects, and it is a contract that's designed for projects that represents the three main parties: the owner, the contractor, and the design applicant, the architect or engineer. And it's drafted by dozens of lawyers and been refined over the years.
Chris, speaking to
Right,
that,
so
what is
let me-
AKAM's role? Sorry, really, could just speaking off that. What is AKAM's role though in the alteration agreement process and in compliance? Does it have a role?
Yeah, of course. I mean, we want to make sure the alteration agreement is solid. We want to make sure that, they're, like I said earlier, that is bulletproof as possible to avoid as many potential pitfalls and you're following all the rules and regulations. But we coordinate between the design applicant, and the Department of Buildings. We want to make sure that they have a full package. Right, so the alteration agreement should spell out all the items required in order for them to move forward. And usually that package, there's a whole checklist of things that have to happen: scope of work, contract, drawings, whatever it is, that needs to be then shuttled normally, if it's permitted work, to the architect of the building, who reviews things to ensure that it's a peer review to make sure that things are in order. And then once they go through a couple of rounds and decide, hey, they've answered all our questions or we see they're following what we think they should be following, then they will say, we have no issue with this moving forward, and it will be up to the board to say, we allow this to move ahead. Since all the professionals agree that we don't see any risk here anymore, or the risk is very low, and they can proceed. And so that's really AKAM's role. I'll pass the baton to Brian. I knew I had something to add.
So going back to AIA contract and proposal. So even an AIA contract needs to be reviewed because sometimes they remove pieces from an AIA agreement. And so we need to check and make sure that all the correct pieces are in there in reference to insurance and indemnification and all that. And if you have a project that is not an AIA, which is a lot of projects that buildings do, a signed proposal provides us no protection. So we have that simple contract that can be used, that all our property managers have access to on our SharePoint drive. And they can use that for any project, from somebody coming in to paint and patch a piece of the hallway. They can have it modified by the building's lawyer to be an annual type contract for the plumber, electrician that's in there 5 times a year, 10 times a year, twice a week, whatever, those go-to people. And we can also have those contractors' insurance reviewed in advance to make sure that that contractor that they're using has proper insurance.
Great, thank you. Brian, going back to your comment about the co-op having a little bit more of a risk involved, can cooperatives enforce minimal liability requirements on homeowners insurance?
Yes, and we're seeing more and more of them do it. Some of them do it by adding it to the house rules. Some of it do it by adding it to the proprietary lease. Adding it to the proprietary lease is more challenging because you need a either majority or supermajority, depending on the governing documents, to get that passed. But it's very important because requiring your unit owners to have insurance protects the building and also protects them, because if they accidentally do something that causes damage to somebody else's unit, that other unit is going to go after that person, and without insurance, they won't have any coverage. Also, without insurance, if somebody leaks on them and is not negligent, just a shower pan leaks, which happens all the time. Nobody knew it was going to happen. The person on 4 is not considered negligent. The person on 3 has $100,000 worth of damage. It's the person on 3's problem to get their own stuff repaired. And if the other person is not negligent, there's nowhere else for them to turn. So it's critical that everybody has insurance. And you
Yeah,
can buy a policy for not all that much money.
yeah, shareholder insurance is a big deal. If you can amend your proprietary lease, it's more enforceable and more airtight to do it. But as Brian said, many buildings are taking the position, I can't get my lease amended, but I want to do this anyway. I'm going to make it a rule and we'll deal with enforcement when it comes to it.
So going to the question about alteration agreements, Chris, there's a question about what constitutes an alteration and what's a good way to classify and categorize it.
So there's basically decoration agreement. And then what I like to call, I like to think of it as 3 buckets. A lot of boards like to call it 2 buckets. So for me, a decoration is something like painting, wallpaper, hanging a television. Minor alterations fall under the legal definition, or I should say the code definition of the Department of Buildings, where they have a section called minor alterations and ordinary repairs, where it is more than paint and hanging a television, but it doesn't require a permit. But it's a little bit more invasive, create noise. If you're gonna replace all your cabinets in your kitchen, I would argue that's a minor alteration, but it's not a plumbing fixture. It's not removing or moving a wall, or changing a window, what have you, right? So I'd call that a minor alteration. And then a major alteration triggers a permit, meaning I'm gonna move or remove a wall. I'm gonna move or remove a plumbing fixture or a gas fixture. I'm gonna modify a window that changes the light and air requirements for that thing. So then those are those 3 buckets. And we actually use a template that separates out those 3 buckets so that then and we have an FAQ, and so the owner can look at that with their architect and walk through it and say, okay, we're doing these things, and so that puts us in bucket 1, 2, or 3, and then they will know which documents they need to provide to AKAM that can then transmit them to the building's architect if it's in bucket 3 to have it reviewed.
And Peter, if a building wants to make a change to their alteration agreements, do they have to seek legal counsel?
They should, because these things keep getting modernized and updated. And whether it's our firm or another firm that does this a lot, we're not starting from scratch. It's not that big a deal and not that expensive to update your agreements to the current proper form. One phrase I use a lot is, it's much less expensive for me to help you build it properly than to fix it when it's broken. And, spending a couple of hours doing the agreements properly versus defending a litigation, there's an exponential difference in cost there. The other thing I wanted to bring up here, because I think it's important, I agree with what Chris said about the classifications of work, but wanted to make sure everyone understands, even for the most minor work, you still need that insurance and indemnity agreement for anyone showing up at the building.
Correct.
And actually, that's a great segue into something that we've been hammered into everybody around here by way of Brian, is that if a contractor is working on the building on any project and goes over to the super and says, "Can I borrow you ladder?" Say no. They have to bring and use all their own equipment and tools, because that will create a liability. Something as simple as a ladder, a step stool, whatever, a tool, a hammer, that guy puts that hammer through his finger, on the job site. Now we have a labor law claim. Now the building is, it ties together. So things that seem silly and like common sense, they can create undue liability. So we have to be really diligent on that.
It's a good point.
So speaking to that, what are some exclusions that people need to be aware of in coverage?
So we're going to start with the fact of we don't want boards or property managers looking at policies to determine what the exclusions are. We'll discuss them, but they're all worded uniquely. So there could be type of work exclusions. For example, the contractor is only insured for painting and sheetrock. Okay. But they're going to do hanging cabinets, not insured for that. We've had people that, like I said, height exclusions.
Yeah, I see that a lot.
Okay. Can't work over 20 feet. So that could be for like even somebody changing light bulbs. Let's say the light bulb is on a high vaulted ceiling. It's over 20 feet. That's a problem. It's a real problem with facades because there's not much work you can do within 20 feet for a facade project. Okay. Can't do exterior work, only insured for interior work.
I've
The
heard
labor
one.
law exclusion,
I
the
think
true
there
labor. Go ahead, Chris.
isn't there one? I could have sworn, and I'd love if you guys can confirm this one. I can't work in the building because it has a dry cleaner.
Dry cleaners create problems for insurance. There are, depending on whether it's just a drop-off dry cleaner, which is generally not a big deal.
Because
But
it's
if
an
it's
outsource cleaning area.
right, because there's no cleaning material
It's
done.
because
It's just
it's about the chemicals in the building.
correct. It's all about the chemicals in the building.
Okay.
So
The other one, Brian, if you want to get into that, I see coming up a lot recently, and I think is really slowing down projects is the subcontractor stuff.
So there's what's called a subcontractor warranty or subcontractor limitation or exclusion. And that basically says if you're going to use a subcontractor, that subcontractor has to have as good insurance as you do, or even though you have the insurance, we are not going to provide it. So a classic example of this is you hire a contractor, they bring in a subcontractor, the subcontractor's employee falls from a height and gets injured. You have a bulletproof contract saying that the contractor is supposed to defend and indemnify, and the contractor has the right insurance where it will defend and indemnify, but they have a subcontractor warranty or limitation or exclusion, and the subcontractor doesn't have insurance, which means that subcontractor's employee gets injured. They sue the building. We go, oh, we got a contract, we have insurance, we're good. We go there, we try to tender the claim off or transfer the claim off to the contractor. The contractor's insurance company says, let me see the subcontractor's work because it was the subcontractor's employee who got injured. They go, oh, they don't have coverage, you don't have coverage. Building gets stuck with the claim.
What about a building employee, like a handyman, if they're cleaning?
Nope.
Not covered.
Well, it's not a labor law issue. Okay, can't sue your employer. It's a workers' comp claim. So building employees, we don't worry about they've got workers' comp coverage.
I think it's also worth noting that I don't know if a lot of people know this, but what we've seen also on a project management side is that a lot of contractors, and you mentioned it earlier, they're not writing, the insurance is much more expensive, the umbrellas policies are much more expensive. So these bigger contracting outfits are the ones that are doing more of the work. However, many of them are subbing out the work. And I guess that's what triggers this exception, that you're just referring to, which we need to be very clear about. We're seeing a lot of times when, oh my gosh, this contractor seems really great and they have wonderful insurance, they have all these great references, and then they're subbing out giant chunks of the job, which could create problems. Now,
Yeah,
if there's,
that's so sorry, I didn't mean to
please pick it up.
We've been dealing with this issue a lot as well, and we've started including really tough language in our riders for unapproved subcontractors. It's one thing when they tell you and everyone knows what's going on and you can do your insurance reviews, but we've started including in some cases liquidated damages and things like that, and default clauses for unapproved subcontractors, because as Chris said, this has come up so much the last couple of years.
Do we at AKAM charge customers for insurance review?
No.
And how is it,
Really?
that? And so two things. One is, what about for building employees that are working on the side for owners? Like maybe they were not.
No, don't do that.
Don't do that.
What happens if it
Bad
does?
girl, don't do that.
This is one of the toughest things there is because every building does it, but the lawyer, Brian, everyone in our position has to say really bad idea because it is really a bad idea, but we also have to acknowledge that it happens in every building.
Let me explain why it's a bad idea. But if the building employee works off the clock for a shareholder, now we have a uninsured, possibly unlicensed contractor in the building. Everything that we're trying to do and protect, we've just broken every rule. And it's a slippery slope because, well, if the building super can do it and he doesn't have insurance, why does my buddy who knows what he's doing, why does he need to have insurance?
Yeah, and even outside of the issues we're talking about today, I'll give you one I'm dealing with now. Shareholder hired the building super to do a renovation. 2 years later, there's a huge leak from a pipe that he touched, and shareholder saying, well, your guy did the work. And in theory, he did it off time and not as part of his co-op duties, but that's a really tough line to walk.
So what happens in that case?
The building and unit owner gets stuck with a claim.
Yeah.
Depending on what has to be fixed.
Right.
So, there's going back to the issue about there's fewer carriers and, the expenses going up, it feels like people are left with very limited options. So the other issue that comes with that is the timeliness. Like it feels like people are forced into these situations. How much time do you need to, align your project manager, your property manager, for major projects?
So it depends on if we get all the information all at once and all the information is good and doesn't need any changes, it could be 1 to 3 weeks unless you're with CMJ. CMJ takes forever. CMJ is a special insurance program, and the program itself reviews everything, and nothing's ever perfect for them, but they have really good prices and really good coverage, so there are advantages. But it could take a couple weeks. I've seen it take a couple months when the contractor doesn't have the right insurance. There's going back and forth in reference to the contract itself.
Yeah, I totally agree with all that. The other thing I'll say, what we started doing as soon as a managing agent sends us a contract now, our first response is, have you gotten the insurance reviewed yet? And starting that process right from the beginning as soon as possible, because you don't want to get to the point where the contract's done, everyone's ready to start, and we're first having the insurance reviewed.
Right, because the insurance can blow the whole thing up, because even if you've got a bulletproof contract, if you don't have any insurance to back it up,
yeah,
the contract's pretty much worthless.
And it's such a long-winded process, really, at the start of a project to go through all that stuff. You don't want to go down the road with a contractor you think is all shiny and new, and you spend all this time talking about schedule and staffing and all this stuff. And he's got an exception that says they can't work over 5 stories for a 20-story FISP project. It doesn't make any sense.
So what in the case of a building has a declaration that gives a limited time for review for alterations? What do you do in the case, I guess, AKAM or Peter?
Well, alterations are different because you're talking about unit owner.
Okay.
Okay. So we do not do the due diligence and vetting of unit owner projects as we do for building projects, for the basic fact that we would probably say no 85 to 90% of the time, because most of these small contractors doing unit owner work have problems with their insurance. So
How do we alert, the board or the resident that there's an issue?
well, as I mentioned, we don't review the insurance policies, because if we did, we'd be saying no, and then there'd be a lynch mob at the board meeting. So every time we talk about this to boards, we explain to them what the issues are and what the ramifications, because if we reviewed it and approved it, then we're approving something that is detrimental to the building.
So the other part of this is, and candidly, I'm not sure if this actually happens or not, but in my form of alteration agreement, I require the shareholder to have insurance also. So that sort of is a check on whether the contractor has proper insurance. And we also have the shareholder sign the indemnification as well. And you always have the apartment as the backstop there. So that's how you can.
Contractor and unit owner sign the indemnification.
Correct. The contractor always does, plus the shareholder unit owner. Exactly.
Correct.
So on the other side, for a project, for like an example, a major facade project, how long would it take for our team to, on average, review insurance, and that way a building can move on?
As I mentioned before, it depends on how we get the information and how it is. It could be a week or two. It could be a month or two if there's back and forth.
Understood. And then going to the question about, which happens all the time, your handyman or whoever that are working in the building, on behalf of residents or what have you, is it worthwhile or economically feasible to insure staff?
The building shouldn't be paying for it. No, if the building employee is doing it on building time and being paid by the building, it's not a problem.
Right, they're covered.
If they're just covered, okay. If the building employee is doing it off hours or is being specifically paid by the unit owner, then we have a unlicensed, uninsured contractor doing work in the building. And if something happens, like if he drills into a pipe, she drills into a pipe and either creates a gas leak or a water leak, and there's damage, there's not going to be anywhere to go against, because you have no insurance, you have no contract, you have no indemnification. That's the problem of staff doing work for unit owners. I know it happens.
Yeah. I have a couple buildings. It doesn't happen often because for most buildings, this is too much of a third rail and they don't want to get involved and mess with people's work. But I do have a couple buildings that make the shareholder or unit owner at least sign an acknowledgement that this person's doing it at off hours. The building's not responsible. They're responsible for everything that happens. But it's, again, I only know of a couple of my buildings that do that. It's pretty rare.
Is there a reason why you wouldn't do that?
The board's scared they're going to be lynched. There's no legal or practical reason not to do it other than the board is afraid that the building's going to go crazy.
Got it. And then, we at AKAM, and I'd love to hear, Peter, how you, work with project management. there's a lot of help that goes along the way when you're dealing with larger projects, such as getting insurance and protecting. From a PMG standpoint, Chris, what do we do to help our buildings, protect against insurance issues, manage the project so it's efficient, work with the insurance team, work with legal counsel where need be?
So, there's a few things I would say. One of the most important things, and the thing I hear about all the time, is people say, "Oh, we have a contractor and we're ready to start the project. Now we're ready to bring on PMG." And I would say, "You're too late." Or we can get involved at that stage, but we recommend getting involved earlier. We want to get involved at the very beginning, where we're dealing with access, we're dealing with insurance, we're dealing with potential contractors, we're a part of the interview process, the whole nine. We like to, we don't have preferred vendors here, but we do keep tabs on what vendors are doing work in different buildings, and so we know which vendors have historically have really, the belts and suspenders insurance, or, they're keeping, they're crossing T's and dotting I's on the whole process of a major capital improvement project. And so I think getting involved really early is really important. Harking back to the earlier conversation about not reviewing insurance for, unit owners doing alterations, the one thing that will help with that is if they're, and what I did when I've renovated apartments in my building is I talked to the resident manager in the management company and find out, do you have a contractor who has done many apartments in this building, who is trustworthy, knows the rules and regulations of the building, has good insurance and the like. And if that person is more familiar and more trustworthy and more skilled, that's probably a better bet. I don't know whether or not they're going to be more expensive per se. But I regularly say that when it comes to vendors, don't choose the cheapest vendor just because they're the bottom dollar. It's about bang for your buck. You want to get the best vendor for what you're spending, not necessarily the cheapest vendor. Because in construction, I could tell you, you usually get what you pay for. I think the same is true of insurance.
And sorry, really quick, can you just say what PMG is in case people are not familiar?
So PMG is our project management group. It's a sort of additional service. It's its own department within AKAM that will serve as an owner's rep. We will shepherd major capital improvement projects through the entire process from inception to completion. We will help you coordinate with your vendors, meaning both your architect, any engineers, your contractors, the process of doing a project. Know that when you do a project, you have to make lots and lots and lots of decisions. And a lot of it is Swahili, and it's confusing, and it's, you need a translator. And so everybody in our project management group has backgrounds in architectural and engineering. They can read drawings. They ask pointed questions. We are checking on schedule. We can review contracts. We're very familiar with the various forms of contracts. We stay in tight communication with people like Brian and Peter as we're putting together the team, as we're moving these projects forward. And then more importantly, the one thing that your design applicant, your architect or engineer is not normally doing is they don't normally communicate with your residents directly. So we can help manage expectations of the residents. We can also work with a committee on the board directly. We provide meeting minutes, updates, cash flow projections, and the like. So soup to nuts, we are sort of on the side of the board to help wrangle everybody so that we ensure that everybody's on the same page as we move the project forward. And it's quite a system.
Great.
Yeah, I've worked with Chris and his team a few times, and I think they do a really good job. And where they're especially useful is those funky projects where a submetering project where you have to get into all of the apartments and coordinating that, or a facade project where you need 3 access agreements to protect the neighboring buildings, a parking garage renovation where you have to coordinate moving cars and dealing with the garage company and all of those things. You need someone really quarterbacking those projects, or they get stuck in the mud and don't move.
And documentation is the most important. And I know that, when you're doing that process, you need to know who did what, who made that action, whose decision it was to paint the wall purple or move that Mazda, so that, you have a record of it. And that's very important when it comes to claims and lawsuits and the like. You know, you don't want to be digging through, you know, thousands of emails or something's off the record because it was just said in a meeting. We take documentation incredibly seriously, and we want to make sure no passive voices there. We want to make sure we know who made the decision, what action was made, how it was moved forward, and how we were managing the situation. And then we are archiving all that information. So if we have to go back on something, especially if there's a claim after the fact, we can unravel it very easily. We could say, oh no, Bob chose purple, or, Joe put in that branch line, this time of day, this month or whatever it is, and there was an issue with the stack or whatever it is. And so having that documentation is incredibly important. And that's also something that, PMG prides themselves on. And I don't think that a lot of architects and engineers are particularly good at on the CA side, construction administration.
Got it. And this is an ancillary service, so this would not be inclusive in your fee structure at AKAM, but you would bid yourself out like you bid everyone else out, right?
That's correct. And we also, and we can also modify, that structure. So if you only want us to do cash flow or handle schedule, we're just going to bill hourly for the work that we do. So you get the value that you need. You may not need everything. There could be an architect on the board and they want to do the whole thing, but he doesn't want to, be a part of leveling the bids, or doesn't want to send out the memos to the residents, for example. We can just do that work. Or you can do the whole kit and caboodle hourly, or as Peter mentioned, those large projects where you're going to every single apartment, like I'm going to replace windows in every apartment, and it's a very invasive project and you have a lot of scheduling and all that such. If we need somebody there full-time on site 40 hours a week, we can do a flat fee for a very large project. And so you probably end up getting more hours than you would have paid hourly for. So you're actually, you're getting it at a discount by having a cap there.
Right. And as far as in-house risk management, that we do not charge for, right, Peter or Brian?
Any discussion of reviewing the insurance and items of that nature, there's no charge for that.
And anytime we talk to you, Peter, it's a lot of money, right?
Not that much.
I'm kidding, but
sure, it's worth its weight in gold, though, right, Peter?
Yes. Well, as someone said, you get what you pay for.
Right, and since we have it, can we have a free question? So my building has a policy that half of the cost of window repair is charged back to the individual shareholder. Does that change the liability insurance picture? Is the work considered as a contract between building and vendor only?
We'd really need to see the governing documents and see where that comes from. Is that just an unofficial policy that's happened, but it's not really written down anywhere? Is it in the proprietary lease? Generally, the proprietary lease governs responsibilities. Most of them initially say the co-op's responsible for the windows. If a shareholder ends up changing them, that could flip that if there's an alteration agreement and everything else. But it really depends on what the governing documents actually say.
See, no free advice. I'm kidding. I'm kidding. But if someone wants to get in touch with Peter or anyone, we've been answering questions throughout, so I hope this was helpful. We have and will circulate everyone's information after. So if there's any questions regarding any legal advice that you need, Peter Massa is a master.
Thank you.
Those questions. And then we have our in-house risk management team under Brian Boak. Feel free to email him. Chris Alker, who's our in-house resident architect, as well as he oversees PMG and operations. And if you need very little advice, you can contact me. No, I'm kidding. I'm here to help as well. So we're here anytime you need us. Thank you so much for joining us. Have a wonderful day and a wonderful weekend. Thank you.
Thanks, everyone.